tomorrow morning.
House Bill 146, Education, Reportable Offenses, and Student Discipline, Children with Disabilities and Reporting. This bill requires that the attorney of a student with a disability, if the student has an attorney, to be invited to participate in disciplinary conferences related to discipline for reportable offense, and prohibits a principal or county superintendent from asking questions regarding the reportable offense of a student unless the attorney is present. If a student with a disability is removed or excluded from their regular school program based on a reportable offense after the removal period, the student has a right to return to the regular school program the student attended before the removal period. Annually, local boards of education must provide specified information and reports to the State Department of Education regarding reportable offenses and related arrests. MSD must provide specified annual reports on these subjects to the Governor and the General Assembly. We have 3 different amendments for this bill. Starting on page 4 of your packet is an amendment from Delegate Atterbury. So this amendment essentially revises the definition of reportable offense to mean that an offense that occurred off school premises and it did not occur at any of the events sponsored by the school, and it retains all of the crimes that were originally in the bill. Then it has that same language that was in the bill, it's just moved to a different location. And she says that the reason for this is schools do not currently classify reportable offenses, removals as disciplinary action, and so reportable offense removals are treated as outside the disciplinary process. So that's, I'm not really sure it actually belongs there. I'm very confused by this amendment, to be honest with you. And then she changes some dates on the reporting. So, yeah, I'll be honest with you. I think there's an issue with this amendment. So the next amendment in your packet is on page 8, and this is by Senator Carrozza, and she adds a provision in here, a piece of information on which they have to report. It's a reporting on a student's academic performance during the time period the student was removed. Includes attendance, completion of homework, grades, and standardized test scores, and any additional disciplinary actions taken by the student. And finally, on page 9, Senator Washington has an amendment too, and I think this does some of what Delegate Atterbury was attempting to do. So if you look on page 14 of your packet, Senator Washington has stricken certain parts of the information that were to be reported. We discussed placement of this language about a student attorney being the attorney of a student who is subject to a reportable offense. The language was put here because the stakeholders were concerned that where it was previously, it implied that this only applied to students with disabilities, and that was definitely not the intent of the bill here. And then finally, on page 16, it begins, Senator Washington is looking for an annual report on school disruptions under section 26-101 of the education article. And then, as you can read right through there, those are the information that she would like reported. Well, I think there's an intent issue here. The intent is that any student who is the subject of a reportable offense, if they're in a disciplinary conference, that they have an attorney. So I think in concept, that is for certain that was Delegate Atterbury's intent and Senator Washington's intent, was to make sure that was in the right location. So among those 2 amendments, I think that can be worked out. I think the definition that Delegate Atterbury said was perfectly fine. And then Senator Washington has a different take on a different report than was originally in the bill. So,
Senator Washington, you want to? So I would say that there's been bills about getting reporting out disruptions, so I thought that this would fit well attached in this bill. And then also I was too trying to clarify. I saw that there's a difference between writing this type of bill in the criminal code, which is versus writing it in the educational code, and so working with Stacy made it fit more of what how we would do things. So is that what you're asking? Yeah, I mean, I'm
Okay.
not sure.
We're going to, first of all, let's get the bill before us. Is there a motion? Is there been a motion? Is there a second on the bill? Okay, let's take up the Washington amendments first.
Yeah.
And since council highlighted it, take care, point us to the issue of the attorney, or the, yeah.
Sure.
Can I just ask a question of the bill so I understand it before
Absolutely.
we try to amend it? So, Stacy, if you can let me know. So this is under reportable offenses that this occur. What are reportable offenses?
So reportable offenses are, it's mandatory reporting to a local county superintendent or our school principal if a student is arrested based on this lengthy list of crimes.
Okay, so
Off campus.
they've been charged with a crime of
They've been
some.
arrested
And it's off campus.
off campus.
Yeah.
Well, that's her definition. The current definition does not say that, but that's,
That's not in the bill yet?
well, that is in Delegate Atterbury's amendment, yes.
Well, let me just also, is being charged and being arrested one and the same?
I don't think so.
No, it's not the same.
Because you can be arrested on suspicion of committing a crime, and then later on, I think the prosecutor comes in with specific charges.
So in this bill, and I'm just trying to get clear, is it charged, is the bill charged or arrested?
So Delegate Atterbury's changes it from charged to arrested, or convicted to arrested.
That's more narrow.
Yeah. It says,
No, charged. You can't be
Arrested is broader. You can be
yes,
arrested and then
is
released.
broader. Right. So the current language says involved in any of the following, and then it has a long list of the
What
various.
page?
I'm looking at the amendment on pages 5 and 6, because her amendment shows that particular section of the law, obviously with her changes. So if you start there, you'll see that on page 4, in this section, the following words have the meanings indicated, and reportable offense means, and she adds, an offense that occurred off school premises and did not occur at an event sponsored by the school and involved any of the following. That lengthy list, that's existing law, and those are all of the crimes or offenses for which as a school or a local superintendent would need to be contacted if a student was involved with.
Okay, can I just back up a little? If you could just start where the bill came to us, and then we're going to try, we have Atterbury's amendments and others.
Okay.
What's the original bill before us, before we amend it?
So the
High level.
original bill before you essentially required in a student disciplinary conference that if a student who was involved with a reportable offense had an attorney, the attorney must be invited to that disciplinary conference.
Okay. Okay.
And that the school personnel present can't ask the student about the reportable offense unless their attorney was present.
And that's the way it came to us
Correct.
currently?
Right.
Okay.
And I'm going to interrupt one more time. Reportable offense as it came into the bill, is that a term of art? And does that,
It's a defined term in the education article.
and is it based on arrest, charging, or conviction?
At
Currently,
this point, it just says involved with. So if a student is arrested, then yes, they are now involved with this crime, and they would have to be reported under this section.
okay, so in the bill as it came to us, an arrest would be considered an incident about each reportable offense?
Yes.
Okay, Senator, back to you.
So I'm assuming, because I didn't memorized all these sections, these are pretty bad crimes, or they range?
They range, I'm sure, but I have not checked out every single reference. So,
Okay, so just, again, the process.
Say felonies and misdemeanors, or?
again, I have not checked out the entire list. I mean, it's
I
a
imagine they
substantial
are, because the
list.
first ones are felonies. So just walk me through the process, because I'm not that familiar. So somebody's attending a high school. They go out and the police pick them up and arrest them for crime X. Under current law, they notify the school system, and then they have to set up a conference or something with the parents and so forth to talk about it and maybe set up a plan. Is that
Yes.
okay? And then, is there any automatic, you have to leave the school, or is that what the meetings do? Because now some of this is starting to come back to me, because I've talked to some people who actually were in this position, and if you were convicted of stabbing or something, which really sounds bad, they don't want to be automatically put out, because they actually had a situation where it was the mother was doing something off the wall and he stabbed them, and they said it had nothing to do with you being in school, we could work with you. How's
So
that work?
if nothing is automatic, if
Okay.
you've been arrested and are in jail, you're obviously not in school. So you can't go to school. But there is no specific consequence currently in the law that requires you to be removed immediately
Okay.
from your
And
program.
does this bill do any, that keeps that the same?
No, this is mostly, it's a reporting bill.
Okay. Okay.
Doesn't specify any specific action. It's a process once that reportable offense comes to the school system. So, Senator Washington, back to you.
Know a lot about that section of the law either, but from talking to the bill sponsor, it's precisely that we don't know a lot about it. And so we're trying to get some information, because there are things that are supposed to happen, but it's once that reportable offense is reported back, but it's not clear that it is happening. So I think the idea is to try to get some information about how it's being tracked and what actually happens.
I assume you want to move your, your amendments, and there may be questions on the amendments. They are in the packet again. Are they in a reprint? Yes. Page 9. Can we get just a 10,000-foot review of these, or a 5,000-foot? Not, what do they change, and what's the implication? I'm sorry. We need to be, yeah.
What they change is the location in the statute where that is put. That's essentially what it does. Hers does that. It changes the place in the statute to make it clearer that this does not just apply to students with disabilities, number one. Two is she adds a different annual reporting requirement for something different. It's not about reportable offenses, it's about the student disruptions on school grounds, if you will.
The sum total of the amendments?
Yes.
And it does include the attorney language?
Yes.
Okay. Please.
I'm looking on page 6 of the packet of the amendment, and it says basically if I understand it, the principal or county superintendent shall invite the student's attorney, if they have one, to participate. But then 2 says they can't ask any questions if the attorney is not present. So how do you get to ask them questions?
Related to the reportable offense. So you could discuss at the conference the student's program, where they're going to go, whether they can come back to school, whether they need to be in a different location, but you can't say, were you present at the time that this event occurred? And you can't ask them, because again, they have a Fifth Amendment right, and you cannot breach that Fifth Amendment right.
Is the Fifth Amendment right that you have to have an attorney with you?
No, that's the right not to say things that you could
Right,
later.
no.
Yeah.
So what I'm saying is, they're saying they can invite them, but if an attorney doesn't show up, they can't ask them any questions about the reportable offense?
Correct.
And I think that's where some people had concern was, you got charged or arrested for stabbing, and the knee-jerk reaction was, let's get them out of school. And if I can't ask you any questions about it, they're going to be booted out of school when it may not be something that really needs to take them out of school. So, I mean, that's what I heard from people who actually worked in the system.
Ask this, I mean, how far along does this meeting take place in terms of the adjudication of the off-campus crime?
So according to statute, and I don't know what reality is, but according to statute, once the information is conveyed to the school system, then a conference is supposed to occur.
So following up with the senator, somebody beats the heck out of somebody off campus. So they're arrested, likely to be charged with a felony of whatever. And there's a concern of that student beating up other students on campus. And they're meeting to talk about whether they should be removed from the school. If it's based on the reportable offense, how do they have that conversation? I guess it's...
Well, they have, presumably, the state's attorney has called the school and given them the information that this student has been involved with this. These are, the bare outline of what's going on. They just can't interrogate the student and ask them, did you do this? Were you present? The attorney is there to protect the student because they often don't know when to say, when to keep your mouth shut, all of those kind of things. It's there to protect their rights in the criminal justice system.
I get all that. I guess my question is, how can you not talk about it if you're going to talk about whether you're should remove the student or not? I don't know.
Yeah, I mean, just the default is get them out. I mean, that's, if you don't talk about it, they're most likely out. So.
Some of your colleagues would be on the other side of this issue of law and order. Okay, Senator Riley.
Could you share with us what happens if there's no defense attorney? Who pays for it? How does the defense attorney show up? Is
It says if
the
the
law
student has an attorney, then,
is the law quiet on that issue?
yes.
So if the child, the young adult, doesn't have a defense attorney, then it will never provide an opportunity to talk about the incident.
No, the way I read it is that the prohibition on not talking about it only kicks in when they have an attorney.
No, it says
No?
unless the defense attorney is present.
Unless, but what if they don't have a
Right.
defense attorney?
Well, then they're not talking about it.
Right. Then they can't talk about the incident. Thank you, Mr. Chair.
It's a gray area. In other
is.
words, in the
No, I
criminal
agree.
system,
Yeah.
you have a right to an attorney or one can be assigned to you. And you shouldn't talk and say something that can be held against you. But here, you're in the school, and they're trying to figure out what to do with you and whether it has implications for your engagement with a school system and attending school, whether you're a threat to others because of that incident or it has no relationship at all, and it should be a non-issue, and you should continue to go to school. Senator.
Chair, don't know why this wasn't cross-referred to judiciary. These seem like very serious legal issues. That's all I'm saying.
It's mostly a reporting bill. I mean, really, it's mostly a reporting bill.
Part of the, yeah, I mean, I hear like there is that gap there, so maybe we need to take some time and talk about what happens if it doesn't. I mean, I agree. Again, just to be honest, I was looking to clean it up because I felt the way it came in was just too cumbersome, so I tried to clean up this section of the bill, but then I also was looking for a vehicle to, get the disruption reporting in, so we can either do it at the end of this day or we can hold it, and because I do think that that's a problem.
I think it's an important bill, but we want to get it right.
No,
We
I
also
agree.
have another 30 bills.
Yeah,
So
no,
it's, We
I'll work on
want to be, so we're going to put this aside and try to figure out how to fit it in.
I agree.
We're not trying to bury it.
Nope.
Okay, so that is, yes, sir.
Procedural question.
Sure.
So on this bill, thank you for that. We got a major amendment from the House committee over here when they sent over the bill. So why didn't they do this over there? Is there a reason why, or is there any rhyme or reason? I mean, it's just.
I plead, I had no idea. Stacy, do you know?
I was given, we often get amendments from House sponsors, but I never get reasons as to why we get them.
My sense is this had complicated legal questions, and their conversation continued after they passed the bill. And I think they came up with these and wanted to forward them to us. But
Okay.
Senator, I know where you're headed. We can take these, not take these, consider them, not consider them.
Okay.
It's our bill in our possession.
Okay. I was just wondering why they would drop it in our lap with these unresolved issues. So I'm kind of new. I'm a fourth year freshman, but I've never seen this before. So I'm
Well,
wondering if
I think
there's-
we've had a few others, actually, in the last week. I can't remember who it's from, but I think, but yes, historically, we don't get a lot of House amendments being thrown over to the Senate.
Okay, thanks.
We are putting 146 on a temporary hold, not a permanent hold. Next. Ms. Foxworth.
House Bill 218, Health Occupations, Nursing, Dialysis Technicians. Oh, I thought we'll wait.
More current list. Sometimes other forces come in and add bills or subtract bills, and so sometimes the list gets amended. Okay, 218.
So House Bill 218 requires a separate certification for certified dialysis technicians instead of requiring them to register as a certified nursing assistant and then separately as a certified dialysis technician. It establishes eligibility for certification as a certified dialysis tech, which includes completion of a training program. It expands the membership of the Certified Nursing Assistants Advisory Committee to include one certified dialysis technician, provides for the expiration and renewal of this new certificate.
How different are the requirements for, I don't want to say simply, but to be just a certified dialysis technician opposed to being a certified nursing assistant?
So they're
CNA?
similar. Both require a program that you have to complete and certification that you went through that program in an application.
Is it,
So-
I hate to call it a lesser standard, or at how many courses, how many hours? Ms. Kaufman is here. You want to come up to the table, Ms. Kaufman?
Thank you very much. For the record, Dana Kaufman. I represent DaVita. Basically, Maryland is the only state that requires a dialysis technician to also be a certified nursing assistant. But to be a dialysis technician, you have to meet a training program right now that is approved by the Board of Nursing, and then you have to pass a national certification. We are not changing any of those requirements. We are just decoupling the need to also be a CNA, because the work that is performed by a dialysis technician is very different from the scope of a certificate from a certified nursing assistant.
Do you know the credits or training that goes into being a certified dialysis person opposed to a CNA?
Yes. So basically, again, it is a training program approved by the.
I got that summary. I'm asking, is it 20 credits? Is it 50 credits? Is it a year? I mean, more specific.
Oh, no. I mean, it's part of the national certification program, and I don't know exactly how many credits it is, but it's the same program that is done in basically all the other states. So it is not we are not reducing their scope. They have to do it now.
Why are we doing this?
It's to decouple because right now, as you know, we have a nursing crisis in the state, and it's very hard to hire dialysis technicians when we're also competing for them to be certified nursing assistants. So the scope
So it's a lower standard. If it's the same standard, then we'll have the same problems whether it's dialysis technicians or CNAs.
No, it's not a lower standard because dialysis technicians have a very specific scope of work. That scope of work is not the same scope of work that is needed to be a certified nursing assistant. So, for example, certified nursing assistants do activities of daily living. They do, activities of daily living. Where dialysis technicians, that scope is very, very narrow. So the Board of Nursing years ago had different categories of certified nursing assistants, but they are not actually in dialysis centers conducting the same scope of certified nursing assistants. So the State Commission on Kidney Disease is supportive of this bill, as well as the Board of Nursing, HFAM, and all of the dialysis centers.
Let's, first of all, put the bill before us if someone feels they'd like to move the bill. Senator Riley's moved the bill. It's been seconded for discussion. Senator Lamb.
Yeah, thank you. So looking through the bill folder here, and it looks like there's initially a letter of opposition from HFAM. Have they adjusted their posture based on the amendments?
No. No, actually, they put that in incorrectly, and they did repeal that. But unfortunately, because of that timing issue of you have to have it 48 hours in advance, their letter did not go back into the file, but we did distribute that letter of favorable to the whole committee.
Yeah, I have a letter dated, it's dated January. For all these reasons, HFAM supports HB 218 and kindly requests a favorable report.
So that's their current posture on the version that we're seeing now?
Yes.
Okay. And then there was also, I guess, a favorable with amendment from the dental hygienists, the Dental Association.
If you actually look at their testimony, they were putting it in for House Bill 219, I believe, but I think they accidentally put it in under 218.
Got it.
Expansion of scope to go from dental hygiene to dialysis.
That was a mistake. I checked that out too.
That would be a shocker to me.
Just checking. Thank you.
Okay, thank you.
I don't see it in the file. I don't know if there's a state association of CNAs. Do we know if they oppose, support, or are silent on this?
They were silent on it. There is not a state association. The Maryland Board of, the Maryland.
Come back to the mic, please.
Oh, I'm sorry. Sorry. There is not an association for CNAs. We did accept all the amendments by the Board of Nursing on this bill, and the Maryland Nurses Association didn't take a position on it.
Discussion on the bill? Anybody wish to be recorded in the negative on the bill? Saying not, it'll go to the bill, to the floor as 10-01.
House Bill 220, Health Occupation, State Board of Massage Therapy Examiners requiring license to practice and other revisions. We did move to concur on the House's changes to the cross file of this, Senate Bill 37. Essentially, the bill alters licensing requirements by requiring massage therapists to be licensed instead of registered after November 1st, 2026. We concurred with changes to keep the penalty at $50,000 for violating certain provisions of the Massage Therapy Act, and limiting the scope of a curriculum that would be accepted to practice. But those portions of the bill are before us, notwithstanding our concurrence with the cross-file. So,
This is a cross-file.
right.
What's the status of the Senate bill?
So we concurred with the changes. They conformed the Senate bill to look like this House bill with
Okay,
the penalty
okay.
and education.
So the Senate bill that
requirements
we've passed is in this same
identical.
posture?
Absolutely.
Okay. A motion, second, discussion? Seeing, yes, Senator?
With the bills going back and forth and trying to refresh my memory, is this the one where we talked about the, I think the penalties, the cost of the penalties?
Right. So initially, we amended the penalty down to $10,000. And when it went to the House, they reinstated it for $50,000. We accepted the $50,000 change. And now, since the House originally retained it at $50,000, that portion is back for our consideration, whether we will amend down to $10,000 or keep it $50,000.
So we kept it
At $50,000.
at 50.
Sorry, no, right.
They sent it back at 50, and we accepted it last week or sometime.
So what's it coming back? Now it's coming back?
It's the cross-file of the same thing,
Okay, so we're
So
at
it's at
50?
50. Yep, we're at
Okay.
50.
up to.
Up to 50, that's right.
Anybody wish to be recorded in negative? Seeing not, go to the floor, 10-01. Next.
Right, House Bill 229, Pharmacists, Administration of Injectable Medications for Treatment of Sexually Transmitted Infections. This bill, we also concurred with the Senate changes, or the House changes to the Senate cross-file, which is Senate Bill 19. Expands the scope of pharmacy for a licensed pharmacist to administer maintenance injectable medications for sexually transmitted infections. The bill does the same thing substantively, but it makes technical changes to accommodate creating a new phrase in the scope of pharmacy article to accommodate maintenance injectable medications specifically for STIs. But again, technical changes.
And this will match the concurrence, which
Right.
is still sitting on my desk. They haven't called up, so we haven't
Fair enough.
concurred yet. But the committee did, but the Senate did not.
Right.
But this will make it conform to that.
Right, it will match.
Okay. This is the cross-file, Senator Lamb, I believe, his bill. Okay, that'll go to the floor as well. Favorably unanimous, 10-01. Next.
House Bill 243, Montgomery County Board of Education Student Membership Scholarship. The bill alters the amount of the scholarship a student must receive who completes a full term as a student member of the Montgomery County Board of Education. The bill requires the scholarship to be applied toward the student's higher education costs, and the amount is subject to certain limitations in the law. There are no amendments, no opposition, and we have a local letter.
Objection to 243. Seeing none, 10-01 to the floor. Let's keep rolling.
House Bill
246.
Bill 246, Open Meetings Act notices, closed sessions and minutes, retention periods, online posting, and public inspection. This bill, we considered it yesterday, placed it on a hold, requires public bodies to keep public notice or written statements about the reason for closing the meetings, increases that standard for 3 years instead of 1 year, which is the case under current law. Requires a public body to post online the reason for closing the meeting only if it's practicable. The public body cannot post the statements, the minutes, or the recordings, and the public body has to oblige the request to provide it to an individual within 5 business days. In your voting packet, which isn't too, don't see the amendments included. Actually, they are included. Trying to find the page, and, yep, don't see one. So I must have a different packet. So I will just explain away. The amendments are from Senator Kagan, and essentially they are in response to MML's concern, thank you, about penalizing smaller municipalities. So instead of requiring all public bodies to provide the documentation within 5 days, if they could not post it online, that portion would be removed. So now it's optional for them to post online, and if they cannot post online, they aren't required to provide it in hand to someone within 5 days.
I know the, the question came up on the floor earlier when we dealt with this kind of stuff. Does the legislature have the same requirements or better? Are we meeting these thresholds?
So legislature is still obligated under Open Meetings Act provisions as a public body.
Right, I know they are open, but we're putting like 5 days and things like that in there. Do we have those same stipulations for the legislative body?
So under this, it's no particular carve-outs, so it applies to all public bodies under the open meetings. So
Okay.
that would apply to,
So we're applying this to the legislature as well?
Right, mhm.
Gotcha.
We're removing the requirement to provide an electronic copy.
right, within 5 days, if it can't be placed online. That's right. So now posting the recordings online is only if it's practicable, only if the specific public body can accommodate that. So the amendment would remove the portion that would require them to make available the portions within 5 days that they could not post online.
Right, but the language that says if a public body does not post minutes, they shall provide an electronic copy of the minutes on request within 5 days.
Right,
That's coming out.
That part is coming out, yes.
Okay. Senator?
Senator
Chair.
Kagan about her amendment. Move it?
Yes, move the amendment.
Second.
Okay, discussion on the amendment? Seeing none, no objection, the amendment, the Kagan amendment on page 11 is adopted. The bill as amended, 246. Anybody wish to be recorded in the negative? Seeing none, that's 10-01. That'll go to the floor. Next.
Okay. House Bill 318, Environment On-Site Wastewater Services Regulation. This is a cross-filed bill, but we have not moved the cross-file yet. The bill establishes the State Board of On-Site Wastewater Professionals as a unit within the Maryland Department of the Environment to regulate and license individuals who provide on-site wastewater services in the state. The department must adopt implementing regulations in consultation with the board by July 1st, 2025 to support the board's operations. The bill also establishes the On-Site Wastewater Professional Fund, funded primarily by fees, penalties, and fines collected under the bill. The bill also establishes reporting requirements, provisions governing license denials, revocations and suspensions, and penalties for violations. Finally, the bill repeals existing provisions related to licensing of on-site wastewater property transfer inspectors.
Would someone like to move the bill? If they have the, it's been moved, is there a second? Second. Discussion. Not all at once. Senator Carozza.
I'm going back to, so this, the cross file is SB 479 on this?
Correct, yeah.
Do we know where the county environmental health, the county environmental officers were on this?
They were opposed as the bill came in. My understanding is that they have not removed that opposition, although the House did adopt some amendments to address some of their concerns. But I think in general, they still oppose the bill.
Thank you.
Yeah, as I understand it, it creates, I'm sorry, Senator Lamb.
Sure. So we've been in touch with, I guess, the Maryland Association of County Health Officers, which includes the local health officers. I think that it seems like they still have some concerns. I mean, I'm supportive of a licensing structure. It seems like their concerns still stem from the structure of the board itself. I know there were some amendments from looking the reprint of changes to the composition of the board. It sounds like part of their concern is that the board, even with this composition, could be comprised mostly of industry representatives. But there's no prohibition on how that might be comprised, I guess. And for a board that would be issuing recommendations to MDE that could be comprised mostly of industry, that I guess they have some concerns about that.
And that's coming from the health department?
From the Maryland Association of County Health Officers.
So what's your pleasure, Senator Lamb? I mean, I don't know if you just want to vote against it, or you have amendments, or you want to hold it. I don't know.
I do not have amendments for this. We just heard about it from Major.
Committee?
Hold till tomorrow.
Fine.
House Bill 372, Baltimore City Board of License Commissioners, licensee hours of operation and enforcement. This is the cross-file to Senate Bill 222, the Senate President's block bill, and it is identical. We have a letter from the delegation.
Yeah, the naive. Yeah, right. Boys' night out. Yeah,
One
yeah.
of your daughters of an indeterminate.
Yes, make sure the paparazzi are not there. Okay, I'm sorry? 372, 3, 4, 5, 6, 7, 8, 9, 902. Okay, we're going to stop that list. First, I've got a second list I want to take up, but I don't know if we should get an explanation. We did get that AG letter, is that right, on cyber?
You want me to pass it? I can make copies, pass it out if you want.
Okay.
while we do the
Okay.
list.
Okay, there is a second list, ladies and gentlemen, and we have received numbers of requests, efforts about Sunday hunting in multiple counties. Bill came in, open totally Sunday. Then there was a suggestion of 7:30, 10:30, and 3:30 to sunset. I have an amendment on all these bills I am proffering, which would allow Sunday hunting from 7:30 to 10:30, which I think one county, I think Montgomery County, has the compromise they have reached over the last couple of years with the horse people. I felt that only leaving a few hours midday for bird watchers or horse people, even though it's on private land, we know bullets don't stop at the end of the property, didn't give them much time, and if they want to ride at sunset. So I think the compromise reached 2 or 3 years ago in Montgomery County of allowing 7:30 to 10:30 for hunting, but leaving the rest of the day to horse people or walkers or bird watchers is a reasonable. So I am moving an amendment on 051, 143, 170, 514, and 556 to allow hunting on Sunday from 7:30 a.m. to 10:30.
So the actual language is from 30 minutes before sunrise until 10:30 a.m.
Okay, thank you. Montgomery's on there. They just need an extension of their bill, but they have the same language. I'll get to them. So that is the proposal I'm bringing to the committee. I can tell you that Senator Bailey in Calvert County has said that's acceptable to him. I have not spoken to the other representatives from other counties. But in my view, if that's not acceptable, they're going to come back to committee. So that's what I'm proposing to the committee vis-a-vis Sunday hunting. Senator.
Yeah, thank you, Mr. Chairman. So with the Charles County delegation bill, is there a letter from the delegation? Because
No, and I was actually going to ask that because one of the senators obviously introduced the original bill, that I do not have a delegation letter. So if there's not a delegation letter, if there's not an interest with the delegation, then we won't move it.
Yeah. I clearly don't want to force this. Because people know where I stand. So I'm whatever you want, Senator.
Well, my delegates are very peculiar and exact on getting a delegation letter. So this came out of there without a delegate. I think I should enforce their rules. So let's hold this until we get a delegation letter from them with the bill that came out of the House.
Okay. So we'll remove 514. It's in our possession. No, I understand what the other counties.
The other counties, I've actually gotten amendments from all the other counties to do exactly what you want to do.
So they've agreed.
Yes.
Okay. Then on HB 51, 143, 170, and hold on, and 556, we will adopt an amendment, or I'm moving an amendment that says 30 minutes after sunrise to 10:30 to allow Sunday hunting. Senator.
Thank you, Mr. Chair, for putting these bills on a vote list. And I, as you know, have been working with Senator Bailey, as well as the county commissioners from Somerset County, who for the second year in a row have asked me on their behalf to make this a priority local bill. Just as way of background, and then we'll get to the amendment. The bill in Somerset County passed clean from the House all day Sunday. Obviously, issues have come up that were raised in the hearings, although I will point out to my colleagues on this committee that the issues that were raised by the Horse Council were not relevant to Somerset County. With that said, there was an effort, because my county commissioners and my constituents asked me to pre-file this bill because it's a priority local bill. When it became clear that the all-day Sunday when this local bill would not be acceptable to the chair, that's when we did come up with the compromise of 30 minutes before sunrise to 10:30, a break, a full in the peak of the day, no hunting prohibited, and then we had the proposal of 3 o'clock till 30 minutes after sunset. Obviously, from the back and forth that was taken to the chair, and we actually had to go back to our own counties and let them know, trying to work with them, because they're asking the questions, why can't they have the same all-day Sunday hunting that 5 other counties have? With that said, that the chair has made his position clear that he will not move the bills unless it's 30 minutes before sunrise until 10:30. So if that is the only offer on the table, I actually had already gone and sent my amendments to that effect to the committee. But I thought it was important. I wanted my colleagues to know that this has been a local priority bill for Somerset County for 2 years. It's hard to explain to your constituents when other counties that are less rural than Somerset County do not have, the same privileges that others. And then in our effort to try to proffer a compromise was rejected. But I understand what's on the table now, and would move the amendment for 30 minutes before sunrise until 10:30.
Thank you, Senator. So again, before us on 51, 143, 170, 556 is an amendment, 30 minutes after sunrise to 10:30. We're going to have this as a consent. On the amendment, discussion. Anybody object to adopting the amendment? Seeing not, these four bills with the amendment, roll call. That, it's separate because they already have that. I'm doing that separately. Correct. It is not on the consent.
And neither is Charles.
Charles is pulled. We're not voting on Charles. We're not voting on Montgomery. We'll vote on Montgomery next because it's an extension. These need an amendment. That doesn't need an amendment. So we're voting on the top three and the bottom bill on the consent as amended.
Senator Lamb? I'm sorry, Senator Kagan.
One day and they forget all about you. My heart's broken. Aye.
Senator Kagan, yes. Senator Lamb? Senator Lamb, yes. Senator Hester? Yes. Senator Hester, yes. Senator Ellis? Yes. Senator Ellis, yes. Senator Gallion? Yes. Senator Gallion, yes. Senator Carozza? Yes. Senator Carozza, yes. Senator Washington? Yes. Senator Washington, yes. Senator Riley? Yes. Senator Riley, yes. Senator Patterson? Yes. Senator Patterson, yes. Senator Simonaire? Yes. Senator Simonaire, yes. And Senator Penske?
Pass. Oh, no, I'm sorry. Yes.
Senator Penske, yes. 11-0.
Now, 485 is just an extension of their current practice. Let the council.
I believe so. Hold on. So, yeah, it makes permanent the authorization for the Department of Natural Resources to allow a person to hunt deer in Montgomery County on each Sunday of the deer hunting season, except as specified. The hunting may only occur from 30 minutes before sunrise to 10:30 a.m.
Motion? Favorable. Second. Discussion? Seeing none. If no objection, we'll record it 11-0.
Would you like to move the Senate bills to the cross files?
Yes. We'll move the Senate bills to the same amendment with the same vote. Ladies and gentlemen, any objection? Okay. Before we go on to the floor, there was a question on the floor on the cyber bill about the USM. We did have a debate, and the decision was to exempt them from the bill. There was a little unclarity on the floor today. Now, Committee Counsel, would you like to tell us about this letter and your conversation with the Attorney General's office?
Sure. So essentially, in speaking with the Attorney General's office on the question of whether USM would be included, University System of Maryland, would be included within that definition of unit of state government because of its unique status within, Maryland. The conclusion is no. The conclusion is that in order for state finance and procurement provisions to provide any mandates on USM, USM has to be specifically referenced. So because USM was never specifically referenced to begin with, the amendment product in the reprints that you see did not include explicit carve-outs because there was nothing really to carve out.
So,
okay. So the bulk of the provisions apply to units of state government. USM still has a relationship with Department of Information Technology because they're referenced within the code under an explicit exemption that says they do not have to have Department of Information Technology oversight over the information technology projects and plans that they institute. So they're mentioned in the state finance and procurement article, which I think is where some of the confusion came from. However, they aren't covered under the definition of unit of state government, which is what the scope of this bill is applying to, or all four, because they would have to be specifically referenced to be impacted by it.
So what I think the issue was, we as a committee took a vote to exempt USM, and that there would be some record of that vote and amendment in the information that would have been forwarded to the floor. That's because there was a vote, and you can see what committee amendment votes show are public. So that's, I mean,
So
now we have a letter saying, well, you didn't have to forward anything because you're not a unit of state government, but it doesn't negate the fact that this committee had a debate, a vote that's not, I guess, is it not showing up at all?
What not showing up at all?
The fact that we took a vote to exempt USM.
Right, so sure, it's public record, and I'm sure it's showing up. It's more of a drafting concern, right? So the motion was to exempt, but there wasn't a specific place in the code to mark out that exemption because they were never included within the code to begin with.
We just affirmed the existing status.
Right, which is that really the portion of the code that we're talking about is mainly codifying what already happens anyway. So we really didn't change anything with that extensive debate that we had. Although substantive and valid, when it came down to actually drafting it, there was nothing to change within the code. There can be intent language added if necessary, but in terms of amending the code,
Senator,
that's not necessary.
it's a fair point. We did spend time talking about it. We probably should have, the motion should have probably been including them. And then if that died, then the current status would have been they're not included because they're not a formal agency. If we want to add some language to reflect that vote, which will only affirm what the Attorney General said, I think we could do that on second or third reader. But I think it's a fair point. Anyway, let's go to the bill sponsor, then Senator Washington and Senator Simonier.
I apologize. I was slightly confused there because I do have a stack of technical amendments on my desk, but there's also language on page 36, which does include the University System of Maryland. But now that we've struck that, given what we're hearing from the Attorney General, it's no longer relevant, right?
But they're referred, is that in the section with Bowie State and a couple of other?
No, there's also language on the language on page 20 is just the procurement list. There's additional language that was struck, I believe, in the House on page 36, lines 15 through 20, that would have included them, but now it's struck.
Right, so, right.
So there's nothing left to strike.
Senator Simonier.
So just to be clear, the statement that the floor leader made about that this does not apply to University of Maryland was correct.
That's correct.
And so to continue to assert that is correct.
Right.
Okay. I mean, I think that's the bottom line, and just wanted to make clear that you didn't get bad information from committee staff. We weren't misrepresenting what was in the bill. That technically, even though it's very technically, that we got the right advice. Okay. Yep.
Yeah, I mean, I think this just highlights we were flying from the seat of our pants, to be honest with you. We discussed it for quite a while. We took a roll call vote on it. You took notes. We're going to take them out of there. We took it to the floor. We got a very technical letter from the AG saying that we renumbered this and we did this and this. And if that was what you all knew going to the floor, it certainly would have been nice to let the committee know that you had found out this really technical information, that our amendment was not needed and we weren't going to be putting that amendment on the bill. So I just...
We all know there have been moving parts, and this is a complicated issue. And it's been 2 years in the making, and we spent a fair amount of hours on it. Communications could have been better on that issue. I think, as Senator Washington said, the bottom line was, what is the intent of this committee regarding vis-a-vis USM? And the result is the same. Whether it should have been communicated differently or it should have come out in light during that debate, or whether we should reverse the motion. all that may be true. And so I think these kind of things happen, not just with this bill, with other bills. I can tell you there are a lot of technical amendments that corrections come up later that we don't even know about, that they're caught and they're brought up, and they are sometimes the technical corrections. But some of what has been said is true, Senator. We have the bill before us, and as I said on the floor today, we have a couple more steps to go unless the other chamber concurs and the governor lets it go into effect. So I don't think your purpose was to block the bill. You spent time on it, and this is an area that you're interested in as well. It's a judgment call of how fast you move the train, or when you concur or accept amendments, as on the climate solutions bill. We all make judgments as to speed and what time is left and how to handle it. And I think we're trying to make the best judgments that lay people can make.
I don't think cybersecurity is a partisan issue at all. I think everybody wants it. We had quite a few amendments. I would have liked to seen the bill before I voted on it, so we wouldn't have had things like this. And maybe council could have came up and said, you know what, the amendment you all voted on, we didn't need it, so we're not going to offer that amendment. I understand one conceptual amendment and have her do it, but there was a lot of them, so I think that lends to the confusion. And then asking for just a little time to look at it, I think that's what kind of pushed the debate, because there was no acceptance of letting us look at it. So I think that's really what happened.
I'm not going to question that. Objectively, however, we recessed. So the second reader is still coming up this afternoon, which means third, unless the rules are suspended, which I don't think they will be. It'll come up tomorrow morning, and there can be amendments on third reader. So I understand having a big bill dumped. We are more familiar with it than some of your colleagues. But again, we might need 24 or 36 hours to do conference, so hopefully there's enough time for people to view it. Okay, I just wanted that. I wanted total transparency. If there's some miscommunications, myself, committee, apologizes for that. Okay. Have the bells gone off?
Yeah.
Okay.
Yeah. Could I just say, what's not fair is demand full committee action on the floor. Members got up on the floor saying that, hey, we don't know about this. This is the purpose of the committee system. The bills came out of budget and tax, finance, JPR. We don't go through the entire process because we'll get nothing done. So I think it's unfair for members' demand we go through the entire process, most of it, whatever. And, it's just it just wasn't a right way of doing it, I believe.
That being said, the bells have gone off. Ladies and gentlemen, we still, I think, I count about 27 or 28 bills. So it's very possible we're going to come back and try to knock some of these out, depending how long we go on the floor. But again, prepare for an hour before session tomorrow on some education bills. So we'll go to the floor and just listen for my announcement. I'd like to knock out some of these because some of them are cross-filed with Senate bills, and I'd like to move these House bills. Thank you. We're adjourned.